Welcome to another edition of CHP Talks. We are here with lawyer John Sikkema, and we're going to be talking about a recent Supreme Court case and focusing on religious freedom in relation to churches in Canada. So with that, Rod, will you introduce our guest and we'll get on with the subject at hand.
Well, it's such a pleasure to have John Sikkema with us again. He is a lawyer and founding member of the Acacia group, and he works with churches, charities, and other faith-based organizations. And prior to joining Acacia Lawyers, John served as legal counsel for the Association for Reformed Political Action, which is ARPA. Many of you know that organization, great organization. And he also worked for the legal counsel of Christian Legal Fellowship. So thanks again for taking time out of your busy lawyer's schedule, John, to join us. And we look forward to hearing what you have to say today.
Thank you very much, Ron.
So the case that we want to talk about this evening was just recently decided, and it was a good precedent. So this is sort of a good news thing that we can talk about. And do you want to just give us an overview of what happened, what started this court case in the first place? And because it's probably one that most of our listeners don't really know a lot about.
Sure. Yeah, so it's involved a conflict in a church. There's a large church. So it's the Ethiopian Orthodox Tewahedo Church. I'll call it the Ethiopian Orthodox Church, which is a little bit shorter. But the church in the Mississauga area, they had a dispute over some doctrinal matters. They thought that there was a certain movement within the church towards kind of more mainstream Protestant theology, which would be distinct from the Ethiopian Orthodox theology. So they appointed a group of lay members who were concerned about this to form a committee. They gave the committee a certain written task, certain written rules. And they said, would you look into this issue and kind of report to the bishop and the archbishop? But the steps to be taken were understood to be up to the clergy, right? So these members gave a report. They recommended certain steps be taken, kind of action taken against those who had these, what they thought were theologically wrong views. And that didn't happen. The clergy thought it was better to just kind of talk things through, not to take these steps. The members on the committee were upset that they thought their recommendations were being taken. Anyway, it all leads to the bishop and archbishop telling these members that they need to, basically seek peace. They need to let certain things go and respect the decisions of the church leaders. They don't, and then they get disciplined by the clergy, and their membership is suspended. As a result, they take the church to court, and they ask the court to reinstate them as members. They ask the court also to tell the clergy to follow their recommendations from the committee that they were on. And they also argue that their religious freedom had been violated by being kicked out of the church. I imagine so a lot of CHP listeners will understand if they're reminded of the basic point that the charter, of course, religious freedom is applying to the government. You really can't really claim religious freedom against your church to not be disciplined, but that was an argument that they made. Anyway, that was the lawsuit. They wanted the court to tell their church to do certain things, including reinstate their membership. And the lower court basically said, without having kind of a full hearing and getting into all, who said what and who did what, said this is not a case that a civil court can or should hear. So that's kind of how it got through to the lower level of court.
Okay. And eventually it got all the way through to the Supreme Court.
That's right. Yeah. So the members weren't happy, of course, with that decision, and they appealed it to the Ontario Court of Appeal, which I thought somewhat strangely, a unanimous, a 3-judge panel on that court flipped and said, actually, this is the case that the courts can hear, basically sending it back to the lower court to say, no, have a hearing on this. Were they fairly expelled, and so on. And we heard about that at ARPA. We found that decision was publicly available. We discovered it. and realize this is a problem. The idea that people can sue their church leaders over what's really internal doctrinal and disciplinary issues, spiritual issues. And so we entered into some conversations with other lawyers who also felt this should be appealed, and it ended up being appealed to the Supreme Court. And the Supreme Court unanimously reversed the unanimous Ontario Court of Appeal. So it was kind of interesting to see. That doesn't, I feel like that doesn't happen too often, where you've got that unanimous, reversal of a unanimous court, but that's what happened.
That kind of does away with the infallibility of judges, right?
Sure. Yeah.
That's a good point. Yeah. So yeah, a three-panel decision versus a 9-panel decision, and to get all the Supreme Court justices on the same page, that's not actually all that common on a decision that's somewhat controversial, is it?
I think unfortunately on some decisions, even on major social issues, think of the Carter decision on euthanasia. That was before Justice Brown was a member of the court. I'm not sure Justice Cote was signed on to that one as well. Certain judges who are more ready to dissent were not dissenting on that one. So that was a bit of a surprise and a disappointment to some. But I think on most cases where it's controversial, you can expect 2 decisions. Sometimes you get 3 or even 4 decisions where the judges split up into different groups and have different things to say. Sometimes partly agreeing with the result or partly disagreeing. In this case, one judge wrote for all 9 of them.
So what was your part to play in this on a personal level?
So being in-house counsel for ARPA at the time, we looked at this from a theological standpoint, Reformed sphere sovereignty standpoint, from the idea that God gives responsibility and authority to different types of offices. So you have church authority, right, to teach and preach the gospel, and to have a certain spiritual authority over members of the church. That doesn't involve physical force, of course. It involves the might and authority of the Word of God. That's different, of course, from the state's authority, even different, you could say, from parental authority and so on. You distinguish these things. So looking at that and saying the idea that because in this case the church had a written constitution, that from a secular perspective, there's a risk of misunderstanding that, which was obvious from the court case, that a court might look at that and say, oh, a constitution, well, we recognize that as a legal term. We're legal people, we're judges, we'll adjudicate this. And stepping back and saying, hold on, if we look at history, and appreciate that churches also have laws and governing documents, and they're capable of taking them seriously, even if they can't sue over them in court. In fact, in some ways, being able to sue for something in your church in court may make you take it less seriously, or not take it as it's supposed to be, as spiritually binding, and you as answerable to the church, and together both of you answerable to God. That's how this is supposed to work. It's not supposed to work by taking your case before secular judges, right? I mean, Paul tells that to Christians: don't take each other to court. He might be talking about you and I if we've got a dispute about who should own the truck that we used to have in our business or something. That is different than taking an internal spiritual church matter to court. And so we're grateful that basically the outcome of this case is the court saying, this is not an appropriate case, the Supreme Court says, for us to intervene in and to settle.
Right. But speaking of intervening, that's effectively what ARPA did, and effectively.
Right. So we were not counsel for the church, but what we do is come to the court and say, look, how you rule on this case is going to affect not just this church, but other churches and with different teachings, right? So for one church from a given culture or background. I'm not saying this is true of the Ethiopian Orthodox Church, but they might expect a certain level of state involvement or state regulation of churches, including the church's internal affairs. And what we came to say is, in the Reformed tradition, that's not the case. We recognize a pretty important distinction, even in John Calvin, well-known Protestant theologian. In his case, there was interesting interactions between the civil government, the city council in Geneva, and his church, and yet he still stood up to the council, the city council, to say, you cannot make the church recognize someone as a member and give them communion and so on. So that kind of the spiritual aspect of the church's authority, even though there was a lot more overlap between church and civil authority at that time and in lots of periods of history, there's already a recognition there that there are certain things, and there's other stories as well, right, of bishops standing up to kings and sometimes being punished for it. But this recognition that God gives you both different roles and responsibilities, and you need to respect each other in that. Often that we think of that in terms of a king or a lawmaker. It's true of courts as well, that civil courts shouldn't assume the authority to decide church and spiritual and theological matters too quickly or at all.
Right. Exactly. Yeah. Yes, when you consider some of the moral implications of the decisions that have come out of the Supreme Court, prostitution, euthanasia, where the courts have not decided on the morally high ground, do you really want them adjudicating matters of any particular church? I don't think so. Not internal matters, right?
Right.
Do you think this this particular case has put to rest any other cases that you are aware of? Like, were there other court cases in the coming up from the provinces that may have been answered by the Supreme Court judgment?
That's a great question. I'm not sure of other cases that were ongoing at the time that the decision was released. We were, in terms of what it may mean for future cases, we were thankful that this case and the case from just a few years ago, a Jehovah's Witness congregation case, that both of them involved basically issues that weren't connected to sexuality and kind of the real cultural flashpoints, where judges might have been more prone, I think, to miss kind of the key historical points of legal doctrine and the distinction between types of authority. So with these precedents in place, I think that where you get, in the future, if you have a church that says, if a pastor adopts a different sexual or gender identity, and the church needs to say, look, for you to adopt that identity isn't consistent with our understanding of a Christian anthropology, and that goes to court. I think having these precedents in place is going to help, because you can point back to that may raise some new factors. It's a different scenario, but it's still fundamentally about the church's internal governance and teachings, and that again, the court, even if it's sympathetic to what it may perceive as a sexual minority, is a term that gets used, that there needs to be a respect for the religious authority and religious tradition to govern its internal matters, recognizing that they only have spiritual authority. They can't go punish people in ways that the government can. They can't take their money and so on. But they do have this moral authority and spiritual and religious authority that we need to urge courts to continue to respect.
So that's a good point. So basically the idea is that all of these two small precedents that you're talking about could build a better foundation for a bigger and even more controversial case that could come up, and probably will come up given Canada's moral leanings in the next few years. and these could be relied upon for a good defense.
That's right. Right. I mean, it's certainly not unlimited. I mean, where you have, so in both these cases, so the Supreme Court decision that was released just a few weeks ago, and in the Jehovah's Witnesses case from a few years ago, you've got members of the church who they're not paid, right? So even when you have a pastor who's on salary, you've got a legal connection there. You legally owe the pastor the money. If the paycheck doesn't show up one week, the pastor could sue the church. I mean, obviously for the church's perspective, that would be inappropriate, but it's certainly there's a legal claim there. There's an employment relationship. In the United States, the courts tend to be much more hands-off, even when it comes to that, even when it comes to paid employees in a church, where they basically say, we're not going to review, did you fire them for good cause, and so on. Canada, it's a bit different. There's general deference to say, if if a church said this pastor is teaching heresy, the court's not going to say, oh, well, we don't think it's heresy. But they might say, did you follow a fair procedure in how you fired this person, and so on. So there's actually a bit of a legal duty there as far as the Canadian courts are concerned. So keeping in mind that this precedent doesn't just kind of apply. It's somewhat limited in its application. There wasn't a legal relationship in this case because they're not paid by the church, but they're also not legal members. So a lot of churches are actually set up where the church is a corporation, and members of the church, whether it's when they get baptized or they do a profession of faith or what have you, while they become spiritual members of the church, they also become legal members, and they get added to the church's members list, which is kept under the church's bylaws if the church is incorporated. In British Columbia, the Societies Act applies to a lot of churches. And actually in British Columbia, there's been some cases where there has been an internal church dispute. They have said, look, you chose to incorporate under the Societies Act. The Societies Act says you have to have certain bylaws governing how people become members. You expelled the member, so we're going to review whether you expelled that member according to your bylaws. And now all of a sudden you do have a court looking at this internal matter. Now the court might say there's certain theological issues we're going to try to avoid, but depending on how a church has set itself up, even when it comes to unpaid, non-staff but church members, you may kind of get your foot in the door of the court, or the person complaining against the church may get their foot in the door of the court by being able to connect it back to the legislation. So in the Ontario case, the church, these church members were not members of a corporation, and so they couldn't use the Ontario Corporations Act to kind of get themselves a right to have this reviewed by a judge. So a lot of kind of detailed technical issues there, but just to say that people should be, especially if someone's listening to this and they're involved in church governance, to understand that it's not kind of blanket protection against any issue in your church ever going to court. It depends in part on how your church is legally structured. And it also depends somewhat on the nature of the issue. Is it a person on staff that you have a legal employment relationship with or not? Definitely more questions to ask, but on the issue of church membership, definitely a solid decision.
Well, that's interesting. It has quite a few nuances and facets to the whole thing, and I'm sure it will get some people thinking about church structure and governance in a way that maybe they didn't before. So, interesting points.
Yeah. So, John, last time you were on, we talked about your intervening on our behalf for the Guelph Right to Life case, and that's coming up soon, June 14th, I believe.
That's right.
And so you will be in Guelph for that, I presume?
Right now, the hearing is scheduled still to be online. Okay. So I'll be planning to participate online for that, and waiting still to hear information from the court about how that's going to work. I'm sure they'll send the link, and then we can ask about, we talked about last time about having a way for people to observe as well. also through, I believe it would be through Zoom or Microsoft Teams. I'm not sure which technology the court will use yet. But yeah, that's coming up soon.
Yeah, well, we look forward to a good result from that case as well. Thank you again for your expertise and passion to defend not only the lives of the preborn, but the right of citizens to protect those, to speak up in defense of those rights.
Thank you. Yeah, and thanks to the CHP for for also standing up for those rights and being an intervener in that case.
Well, it's I think we've seen through these two conversations last week and this week the importance of intervening and as CHP saw back when we were actually taken to court by the city of Hamilton, the importance of precedent in terms of defending rights in this country. And so this work continues, and it's interesting when the work of CHP has been able to intersect with court cases and precedents and intervening. And we're so glad that, John, you're on our side in this next phase of the battle for freedom and freedom of speech, obviously, in that one. But thanks for what you're doing.
Yeah, thank you very much. Yeah, very good to join you.
Talk to you again.
All right,
okay.
And so thank you all for listening. I hope you learned something from this informative edition of CHP Talks. Hope you'll join us again next time.
And we hope to be back with good news after June 14th.
That's right.